Hi everybody, I'm Jasmine Dodson with Dodson Legal Group, and today I'm going to be going over some basic definitions of estate planning. What is an estate plan? An estate plan is a representation, a formal representation of how you want your assets to be distributed when you pass away. One of the most common concepts of estate planning is a will. What is a will? A will is a legal binding document that essentially tells the court how you want your assets to be divided. With every will, you're also going to need to have an executor. Now, an executor is the person that you designate and identify as the person who is going to carry out the wishes and desires in your will. My go-to is I say, always look for somebody that's hot, right? You want somebody that is going to be helpful, someone that's going to be organized, and someone that's going to be trustworthy. Now, a trust is an agreement that you make that identifies all of your assets and it sets out where you want them to go. A will has to go through probate, and a trust, the administration of a trust, is more private. The most common trust is called a living trust. You might also hear it called a revocable trust or an inter vivos trust. It's all the same thing. It's all a living trust, which is also revocable, that you can utilize when you're living, but also helps to manage your assets after you pass away. An irrevocable trust is a trust that you essentially give your assets away to be managed by someone else, so you no longer have control over them. An irrevocable trust is less used in estate planning and is more used for asset protection purposes. One of our favorite people in trust creation is the grantor. The grantor is exactly what it sounds. It's the person or persons who grant the trust life. These are the people who are essentially the founding members of the trust. They are, if you're in a generational trust, these are your great-great-great-grandparents who granted life to the trust so that you can have the assets you have today. There's a huge difference between a guardianship and a medical power of attorney or even a general power of attorney. A guardianship is where the person's rights are actually taken away from them and they no longer have the ability to say where they live or how their estates are managed. With a medical power of attorney and a general power of attorney, those can be revoked as long as the person who drafted them still has their capacity to do so. So if you're drafting a power of attorney or a medical power of attorney and you decide you want to change the people that you've designated, you can make those changes at any time. However, if you become incapacitated and you no longer have the ability to say who you want to be in these positions of power over you, and there's a guardianship in place, it can only be changed through the probate court. So if the grantor is our favorite people, the trustee is the most important person in the trust. The trustee is the one who you trust to carry out the desires of your trust agreement. Now, if you're just creating a trust, you're going to hold both of those positions. You're going to be the grantor and you're going to be the initial trustees. So you're going to give life to that trust, you're going to create it, and you're also going to manage the assets during your life. When you pass away, the idea is to designate someone else to step into that position of trust, to act as the trustee, to manage your assets how you've already determined they should be within that trust agreement. When you're creating an estate plan, you want to identify the beneficiary of your trust or your will. And now the beneficiary is the person who you've designated to receive all of the assets of your estate. And the beneficiary could be your children, could be your grandchildren, it could be a church, it could be a charity, it could even be your dog. You just have to identify someone that you want your assets to go to. So the best way to do a distribution of your assets is make sure that it's a clear distribution. You identify what you want someone to have and you identify who you want it to go to. Whether you have a will or you have a trust, you have to decide on your schedule of distribution. Generally with a will, the distributions are made towards the end of the administration and it's a one-time thing. But with a trust, you have a little bit more flexibility in that you can decide whether or not you want your beneficiary to receive a distribution at a stated age or at a stated time. A very important estate planning tool is a power of attorney and a medical power of attorney. Well, for these documents, it's generally when you turn 18. You want to have a power of attorney or a medical power of attorney. Those documents essentially state that you've identified someone who can speak for you. With a power of attorney, it's for your business, like your banking, your assets, your real property, things like that. With a medical power of attorney, it's for medical decisions. So you want to be able to have somebody already designated to make these types of decisions for you if you are unable to do so for yourself. A guardianship is when you no longer have the capacity to make decisions for yourself. And unfortunately, these are my clients that might have a traumatic brain injury or suffering from Alzheimer's or dementia, and they no longer have the capacity to take care of themselves. So this is where a court essentially determines that someone is incapacitated and that there is a need to appoint a guardian. At this point, everything goes before the court. There's a doctor that has to certify that the person is incapacitated, and your rights are taken away and are vested in someone else who is going to make these decisions for you.